Hello and welcome to the show. We call this Molotsky on Money. What's the show all about? Well, the clues are in the title. We'll be discussing money, specifically investment strategies, taxes, estate planning, insurance, and many other topics, all of it designed to help you and your family improve your overall financial picture. The Molotsky part of our title comes from our panel. Their name is Molotsky. Each week, we'll have Stan Molotsky, president and founder of the SHM Financial Group, as well as Lee Molotsky, vice president of the SHM Financial Group. We invite you to stay with us because we have valuable information on this show and every show that we hope everyone can benefit from. And as we like to say, Stan, here on the show, tonight is no exception. We're going to be talking about something that I guess people sometimes tend to push to the side or forget or don't think they need it, and that's legacy planning, or some call it estate planning. Explain what that is and why it's important.
Well, it ties up everything that you're doing within the accumulation of the money. When you pass away, when you die, where does the money go? And the legacy planning in turn instructs how that money is to be dispersed to the heirs, because if it's not set up properly, as we're going to talk about in a few minutes with some of these very famous people, the government winds up getting the majority of the money in a way that the people who passed away don't necessarily think that that's going to happen.
Right. Leon, I know you meet with a lot of people, and when it comes to this particular topic, they say, well, listen, I don't have much. When I go, my wife will take care of it, so I don't really worry about it. What do you say to something like that? I'm sure you get that a lot.
I'd say what I tell my kids is you're being silly. Right? That individual's being silly, yes, to think that whatever they have will be taken care of. You really have to sit down really seriously and decide who gets what. And if there's issues in the family, unfortunately, a lot of families have either medical issues or kids that spendthrifts, or kids that with monetary issues and spend a lot of money, or relatives or married children who are married who they don't want to leave to the outlaws, so to speak. So it's really important to sit down and actually design something so it goes to where you want to go.
And things change constantly, so this is not a one-time done and forget it. You know, children get married, children get divorced. Parents get married, parents get divorced. Then there's children, there's stepchildren, and there's a multitude of different factors that all enter into what used to be called the traditional family unit. There is no such thing anymore.
I was just going to say, today it's multiple marriages, multiple children, stepchildren, step-grandchildren.
Adopted children, all these things have to be addressed in part of what we call the legacy planning.
Okay, and we're going to go over, so you have an idea of what we're talking about here. These are common legacy planning documents, and basically it tells you the things that you need if you're going to do this properly, and it's a will, a durable power of attorney, a healthcare directive, and letters of instruction. Lee, you want to start from the beginning, the will?
Sure. I mean, basically you need to sit down with an attorney, someone you're comfortable with, and design a will based upon your goals and objectives and who you would like to get what.
Do you go to an attorney who specializes that? I know you have attorneys that you work with.
We do.
Do you go to those kinds of attorneys, or can any attorney draw that up?
I mean, if it's a simple will, you could probably go to any attorney. He or she will tell you if they can do that or not. But there are attorneys that specialize in wills and estate planning. Probably better off going to them. But at least go make a step one to your own attorney.
Like going to a specialist when you have a doctor, you have a special condition, you go to a specialist who does that all the time, correct?
But generally speaking, you go to the generalist first.
Right.
And the same thing with an attorney. If it's not a complicated situation, it's basically husband and wife and a child or two, goes to each other, then to the children, and it's not a lot of complicated things within it. It could be done by a basic, an attorney who doesn't necessarily specialize in that. Like Lee said, we are not attorneys. We have an attorney on staff who looks at those things and then suggests what should be done based on the goals and objectives of the client, and then refers it, like Lee said, to a half a dozen different people who actually do the drafting of the instruments.
However, I I have seen many cases, at least a half a dozen cases, come through office where they went to an attorney who doesn't specialize in wills and estate planning. And the attorney did a will, and we talk about whatever, and we realized that the attorney failed to address 3 or 4 assets that didn't pass through the estate via a will. They bypassed the will. So monies were earmarked for ex-spouses, children who they didn't talk to, et cetera, and that was not the intent.
Right,
So
and
if
that's
an
a problem,
attorney-
obviously,
yes,
right?
Sure, well,
if
it's
an
what-
attorney doesn't specialize in or is not up to date in his or her practice as far as wills and estate planning are concerned, it can be somewhat of an issue.
All right, I want to ask you about the other aspects of the legacy planning, the durable power of attorney. What does that stand?
Well, basically, it says if if I become incapacitated, there's someone that's available through the durable power of attorney to handle the bills and make some changes within the investment accounts. If I have a financial power of attorney, forgetting the power of attorney you need for medical purposes, so you need that as well. So you need the
need
financial,
one
the medical.
so
right.
there's 2 powers of attorney.
Yeah, sometimes it's incorporated in one, but you have to specify. We would suggest that you specify specifically what goes with what.
And Lee, the healthcare directive, what does that mean?
It has to do with your health. I mean, if you have an issue, health-wise, you're in the hospital, can't function, can't mentally think, unable to, you have to have the ability to someone in your family to make a decision on your behalf if you're incapable mentally of making a decision.
Okay, we wanted to show you some situations. We did this is actually the second time we've done a show on legacy planning, and we had a great reaction to the last show because we were showing you some famous people who you would have thought would have known better and who made a lot of money in their career. And so we thought we would continue with that theme. And this is estate planning failures. And who was this first one we're showing, Lee?
This is Mr. Jerry Garcia, the basically the head of the Grateful Dead.
Yes.
And if you're a music fan or a Grateful Dead fan, you know who he is. But long story short, Jerry Garcia had 3 wives, not at the same time, but 3 wives, and a longtime girlfriend.
He may have had 3 wives at the same time. Maybe
Maybe back in his
Jerry
day.
Garcia, right?
It was a little off the
He was a
wall.
heck of a guitarist. But anyway, he died of a heart attack in 1995, I think it was. But an ex-wife that said that he had unfulfilled his promises to her. So long story short, he had a will. Many, many years and issues later, the administration of his estate is still under contention.
This is 1995, so this is now what, 18 years?
18 years later.
And they're still fighting over this?
Well, there's a lot of money involved.
Right, and what's the problem with was the will poorly drafted?
No, I guess you can have a will contested. So
So-
an ex-wife of his has contested the fact that he promised her many things, and apparently, according to his will, she was left out in the cold, so to speak. So she's contesting it. I guess that can go on and on and on until
It gets
who
resolved.
knows when.
So what would someone, and again, obviously not everyone is Jerry Garcia, but what would someone in any situation like that with 3 wives and 2 kids and stepkids,
4 kids,
4
exactly.
kids, whatever it
5
is,
kids.
I mean, whatever, all of that stuff, what should they do to avoid potential problems after they're gone?
Again, we're not attorneys, but often the individual should, again, don't want to practice law, not an attorney, didn't go to law school, wants to specifically name that individual in his or her will to make sure that it's named, he or she is named as a beneficiary. Maybe $1, maybe $1,000, maybe whatever it is, but at least name it so therefore you're specifically named and you can't
say I was left out if you
I
were
was
named
left
it.
out if you're named in it.
Right.
That's what he did
So-
not do.
Oh, so he didn't
Apparently he
name,
failed to name this ex.
Right.
Promised her the world, apparently,
or so she says.
so she says. And he didn't mention her in the will.
Okay, we got more to talk about here on the show. It's Molotsky on Money. We are here every week at this time discussing a variety of issues. Tonight we're calling it Legacy Planning Part 2. We have a lot of stories to tell you, a lot more information. So whatever you do, don't go away. With Stan and Lee Molotsky, I'm your host, John DeMasi. More of our show after these words.
Just as it's extremely important to have your automobile's brakes tested, we think you must have some type of safety net provisions in your financial plan. How are you protecting your bond positions from rising rates? How are you protecting your stock market gains from market sell-off? Do you have the proper provisions in your financial plan to assure that your income lasts as long as you do? Are you keeping up with inflation? Call 1-800-MONEY-SHM to schedule your safety net review. That's 1-800-MONEY-SHM. Not everyone can endure the ups and downs of the market. When planning for retirement, you can ride the roller coaster and take your chances, or you can eliminate the downs by properly repositioning most of your portfolio. If you're 5 years pre-retirement or 5 to 10 years into retirement, it's not too late. As a matter of fact, it's never too late to avoid the next down movement. Call the SHM Financial Group at 1-800-MONEY-SHM or check us out on the web at shmfinancial.com.
Welcome back to Molotsky on Money with Stan and Lee Molotsky. I'm your host, John DeMasi. Don't forget, from time to time, we put the number up on the screen where you can contact Stan or Lee Molotsky or any member of the SHM Financial Group, as well as the email address or the website. Feel free to go on there, get all the information you need, and certainly, if you have some questions, you want more information, Stan and Lee will be happy to talk to you in the privacy of the office. Tonight here on Molotsky on Money, we are discussing legacy planning. This is part 2. We did a show on this a couple of weeks ago, and we have a lot more stories to tell you about legacy planning. And you know what's amazingly, all of these people, and we're going to show a lot more now on the show, but all of these people were so well educated and were successful and made a lot of money. But when it comes to this kind of stuff, I mean, they made some very, very basic and glaring mistakes. Did you find that when you were, I know you put this together, which I thought was a great piece, but didn't you find that kind of odd that this happened?
One of the folks that we'll talk about a little bit later tonight, complete and utter shock of how his estate was planned, for the reason that he was a judge.
Right.
So
yeah, he was pretty famous. So.
It's not just a judge.
That's right.
He was like one of the major
one of
judges.
the grand poobahs. So
Right.
Exactly.
it doesn't surprise me. Musicians, actors, actresses, famous people, they're just like you and I.
Only they make more money than us.
Although
That's
they
the
have
little
a
bit.
larger, maybe they have a larger estate.
Right.
There's mistakes made everywhere by individuals who are somewhat careless. They're focused on their career. They're actors, they're actresses, they're sports people, they're musicians. Jerry Garcia. That's not what they do. They leave that to their professionals, assuming they even got something done. Jerry Garcia had a will done. It wasn't done well enough, but it was done.
Right. So he thought it was okay.
I'll check that off, that he did what he thought he was supposed to do. Our next case, a little bit different, probably should have been updated a little bit, and we'll talk about how why it's important to be current in your will and your financial and estate planning.
And
So,
speaking of the next case, this is estate planning failures we're going over of the rich and famous, and this is Heath Ledger. And a very sad story that he died, of course, of a drug overdose at a very young age. But Lee, what's the story here?
so here, long story short, he died of a drug overdose. He had a daughter. He had a will that he had done way before he became famous, and way before he died of a drug overdose. The will was drafted in Australia before he became majorly successful and fathered a child here in the U.S. So when he died, the problem is he didn't account for the fact that he had $20 million in assets. Those assets went to his parents and his siblings. So in his particular case, his family said they would give the entire estate to Ledger's former girlfriend.
Who's the mother of his child?
Who's the mother of his child. So not everything is terrible in Heath Ledger's case, other than the fact that he OD'd.
Well, what does that say, though, about those people, Stan? I mean, $20 million, they could have said, hey, you know what? Here's a couple of million, we're keeping the rest, but they gave it all. But that's not normal. You don't really see that, right?
No, that may be the one time out of a zillion times that you'll find something like that happening.
Yeah.
Most of the time, it would be maybe they'll give a nominal amount or whatever the case would be. And like you said, they didn't have to do that, but they did do that.
And this, we showed this because we wanted to show you that not everyone, even though as a failure, it wasn't really a failure, but it ended up good. But if they would have gone by the letter of the will, they didn't have to.
Exactly.
The moral of the story here, not immoral or moral, but the moral of the story here with Heath Ledger was that, fortunately for him, it worked out. He passed on. But it worked out financially. What you need to do the moral of the story here is that you need to keep your will current.
Right.
It can't just be from 20 years ago or 15 years ago.
Or
when
from
you-
another country if you're
or from
working
another
in this
country.
country,
So
right?
You need to update your will, and you need to have power of attorney, which he didn't have to address. But
Right. Okay, our next case, and we alluded to this earlier in the show, and this was, I think Lee made the comment, he was the grand poobah, maybe you said that, Stan, that he wasn't just a judge, he was Supreme Court Justice Warren Burger. Now, this particular case, Lee, I mean, you would expect someone in this position to never make this kind of a mistake. Talk about what the problem
there's
was
a
here.
bit of a surprise, needless to say. Age 87, he passed on, had congenital heart failure, left a will, 176-word will. I mean, it's probably half a page, 3/4 of a page. And he left the will, he left his 2 children. The will he left failed to empower his executors and did not plan for estate taxes. Hello? Hello.
Well, I mean,
Yeah,
and
maybe
you-
he's not an estate planning attorney,
But you
he is
figure-
certainly at the top of the hill.
Right. You would figure
top of
he'd
the
have to
mountain.
know something or at least have had
Again,
cases like
it's
that.
a neglect.
Yes.
Needless to say, he's focused on his career, Supreme Court justice, main guy, not focused on what he really should have been focused on as part of what he was doing as he's moving on. But at 87, I would think he had plenty of time to kind of line up his ducks.
Right. But Stan, what in that case, he failed to plan for taxes. So they had to pay like $450,000, I think it was, out of there, plus the probate expense.
He lost about a third of the
About a
estate.
third of the
Yeah.
estate.
What would you have, again, you're not the attorney, but if he sat in your office and you had an attorney there with him and you, what would you have suggested? What would you have done differently?
Well, either I or the attorney certainly would have suggested that, by the way, if you don't do anything under today's tax law, you're going to lose a third of this to the government. Now, you work for the government, maybe that's what you want to do to help them along, but if you don't want to do that, there are certain things that you might want to consider doing, such as trust and making gifts and having it earmark specific things for whoever it is you want to do it. You might want to adjust that and change it and have the attorney draft whatever the instruments would be. I mean,
My question is, I wonder, actually, who his attorney was.
Right.
Well, that's
that's
To
another
me,
question.
I'd like to see who the attorney was.
Right.
He made a mistake.
And so did
but
the attorney.
I would say his attorney really.
Made a bigger mistake.
Exactly.
Well, he may have.
Who knows?
Well, who knows is right. I mean, he may have drafted this at a certain time when there may have been less assets and there may not have been an estate tax situation at that time.
Might have been,
And then,
yes.
well,
I
I
mean,
did it
forget-
and not paid attention to it.
Forget who he was. There's a lot of people with $2 million in assets.
Yes.
Well,
a lot.
Yes.
Who
Yes.
may have done the same thing.
Who are doing the same thing, because a lot of times we'll say, oh, one of the questions we ask, do you have a will? Oh yeah. Can I ask when it was done? And the husband will say, oh, we just had it done, and the wife will say, we did that 15 years ago. Well, in some people's mind, that's just yesterday, but it's not. So, and in the 15 years, a multitude of things have changed, including the estate tax law.
Okay, we're coming up on a break, and after the break, we're going to show you one more case, and this one, I don't know how you could have missed this one in the news. Anna Nicole Smith. Boy, there's a story, and a story, and a story, but we'll show you that one, plus more to talk about here on the show. It's Molotsky on Money. We're discussing legacy planning tonight. Do you need it? What is it? How important is it? We're talking about all of those aspects of legacy planning. With Stan and Lee Molotsky, I'm your host, John DeMasi. We return with more of this edition of Molotsky on Money after these words. Stay with us.
Since 1958, the SHM Financial Group has been providing sound financial insights and strategies for people just like you. Founded by Stan Molotsky, the SHM Financial Group believes in safety, security, and preservation of principal. For more information on how the SHM Financial Group can help you, contact them at 1-800-MONEY-SHM. That's 1-800-666-3974, or visit them at shmfinancial.com. Call us to discuss the reverse mortgage concept. If you should decide to proceed, you're required to go through a 60-minute phone or office interview. We will provide you with a list of HUD counselors you can call who will provide you with the counseling. Call us at 1-855-HUD-REVERSE. That's 1-855-483-7383.
Welcome back to Molotsky on Money with Stan and Lee Molotsky. I'm your host, John DeMasi, discussing legacy planning tonight. And before we get into our next case, the story of Anna Nicole Smith, I think it's important, Stan, that we mention, and you mentioned to me during the break, that we're talking about cases with a couple of million or 20 million. You don't have to have that kind of money to do the legacy planning, correct?
No, everybody, let me say this one more time. Everybody should have a will, and they should have the powers of attorney, no matter what, just to address what they have. And the less you have, the more important it is to make sure you're protecting it and it gets to wherever it is you want it to go. Spouse, children, grandchildren, church, synagogue, wherever you want that money to go. That's why it's critical to do the planning. And that's part of the process that we introduce in the planning process. It's not the financial process, but it's the distribution of the financial assets within the estate itself.
And a lot can happen if they don't have this.
Oh, as we're pointing out.
Right.
Absolutely. Absolutely.
Families fighting, I mean, that never happens, does it? Okay, we promised you the story of Anna Nicole Smith and talk about estate planning failures, or we could talk about other failures as well. But Lee, what was the situation here?
We all know, unfortunately, that she died of a drug overdose, whoever she really was. The model, quote, turned public curiosity left a will, but it was apparently a goofy document, shockingly, that disinherited her daughter. Her will had specified leaving out any, quote, spouse and others, heirs, including future spouses and children. Her 20-year-old son had died shortly before Anna's death. The court eventually made Smith's daughter the sole beneficiary, named a guardian, which Smith did not do. Another state case Smith was involved in still lives. Smith had married, of course, 89-year-old billionaire Howard Marshall. Shortly after he died in 1995, her claim to the estate is still in the court system.
Let me see if we get this straight here. Anna Nicole Smith has a son who's 20. He dies before her. Then she dies, but the will disinherits any spouses or children. So who is supposed to get that money? Now the daughter, some court decides the daughter's supposed to get it.
Goofy is as Goofy does.
Right,
I mean,
but
she was goofy.
But she didn't get the money from the billionaire husband because his family contested that, correct?
It is
and it's still,
as far as I know, it's still in contention.
and this is how many years later?
20? No, I don't think it's 20.
It might not be that long, but
We
was
can put that,
90s.
let's put that back up there.
Can we
for
put that
1
back up,
second.
Justin,
It was
see what the...
in the 90s,
about
maybe.
1995 he's
10,
telling us.
15 years ago.
1995.
Yeah,
she did.
15,
Yeah, right.
yeah, well.
So 18 years, here we go, and we're still fighting
Is
over...
that how long it's been? 18 years.
18 years, so we're still fighting over this? I mean, so this one is very complicated, but to sum it up, Lee, how would she have avoided, I mean, could you avoid any of this mess, but...
I can't even begin to, she's just bizarre, strange, goofy. Make sure your I's are dotted, T's are crossed. Make sure you name in your will specifically who it is that you want your funds to go to and how you want them to get it.
And like Lee pointed out before, even if you want to exclude somebody, you include them for that $1 or $5 to make sure that the courts know that you addressed the fact that you didn't necessarily want them to get more.
acknowledge
But
that
you didn't
person.
forget them.
You didn't forget them, so they can't say, oh, he promised me. Well, here it is,
Under
you got
the-
$5 in the will.
Exactly,
Okay,
right.
all right, we have some questions here from folks, and again, either from previous shows or from some of the seminars or a variety of sources. This is Jennifer in Browns Mills, New Jersey. She says, my dad passed away about 2 years ago and left me and my sister a substantial inheritance, somewhere in the 6 figures. I had been married but not divorced. My ex-husband, who lives out of state, has hired an attorney and is claiming that he's owed at least half of that inheritance. I'm really sick over this and was wondering if I should hire an attorney. Another question I have, is he really entitled to anything?
We don't practice law. Let me say this, we don't practice law.
Yes.
This is one of the reasons we don't practice law. We're not attorneys, but this stuff is messy. Nothing's ever
This
clean
does,
cut.
I mean, again, I've known
Right.
you guys for years, and doing these shows with you, I'm looking at this and I'm going, this sounds like a real mess.
It will be, yes, it will be. And there's no right answer for that.
Okay, but the
This
question...
is a he said, she said, you know, who am I entitled to what? We don't know because we're not attorneys, but you really need to make sure that your documents are lined up properly and that you're doing the proper estate planning so that the assets go to whom you expect them to go to. I don't know what the mother had put in her plan.
Her
father,
dad
I'm
was
sorry.
Yeah. But She's asking if she should hire an attorney.
Absolutely.
I say absolutely, right?
No
Yeah, no
question.
question.
There's no question.
And should it be an attorney who specializes in these kind of
Absolutely.
things? Okay.
Absolutely.
So that's what she's got to find.
And there are so many out there who are exceptionally good at what they do. So it's not that difficult to find. And if anybody has a request for that, we have a list of 6, 7, 8, 10 different ones in particular fields that we have worked with in the past that we would be happy to suggest that they consider.
When someone comes to us with a complicated financial question,
Like this question.
well, that's a legal matter. So, being 50 plus years and almost 30 years in the business, we can pretty much figure out anything. If not, we have to go to our counsel and figure it out. An attorney should be able to look at this clear cut, give her an answer.
Right, okay. We have more questions here. We'll try to get to as many as we can before we leave you tonight here on the show. This is Clyde in Cherry Hill, New Jersey. He said, do we really need a will? My wife and I have been married over 35 years and have no children. We have no one to leave it to since our nieces and nephews never visit us or call, so we don't really feel they deserve it. My wife keeps saying we should have one anyway, and I say, why bother? What do you think?
Absolutely, definitely needs the will. Just need the will, because those nieces and nephews may make some sort of claim on those things if there is not a will.
This is a woodwork case. The nieces and nephews, when they Clyde is
Come out of the woodwork, right.
Come out of the woodwork.
Yes.
So if they want to make sure that the nieces and nephews are spoken for or about, leave them $1 apiece.
Exactly.
Specify niece 1, niece 2, niece 3, nephew,
nephew
1,
2, right.
whatever it is.
Right.
Specify it that that's what they get.
But they
So
have to
I'm sure-
figure, don't they have to figure where they're leaving it to?
Well, there are plenty of charities that could use their money, or
Right.
other
Okay.
organizations, that need money today, hospitals, whatever.
I mean, they could take some of their assets. They could make a gift to their, church or United Way or Red Cross, take an income from that for the rest of their lives, and the corpus of that then stays with whoever the charity would be, and then that way.
And quite frankly, what we do in many cases, we set up family foundations. So Clyde could set up the Clyde Family Foundation, make a major contribution to that. We can help him and his family manage those monies, and then at his passing, those monies can be distributed to various
Excellent, right.
various
Okay,
institutions.
we're going to try, we can get to one more question, I believe. This is from Doug in Morristown, New Jersey. He says, I've been in business over 40 years. My son has no interest in the business, and my daughter is married and living in California. As far as my estate planning issues are concerned, how do I go about implementing a succession plan with no one to leave the business to? Stan?
Tough choice, but you have to start entertaining that from day one. Like, what is going to happen to that business, and what's going to happen to the value of that business from an estate planning point of view? Because if no one's interested in that business, when he dies, what's going to happen? It'll be assessed, the business may deteriorate, and there may not be assets in turn to be passed on.
Should he sell the business?
He could either sell the business or make arrangements from it, or he in turn could take out the equivalent value of that business in an insurance policy, so in turn name specific beneficiaries of the insurance policy to avoid any possible loss within the business as far as deterioration in value when he's not there.
And with that, we are going to put the wraps on another edition of Molotsky on Money. Don't forget, if you want to call, you want to email, you want to go on the website, Stan and Lee will be happy to talk to you about any particular issue that you may have. For Stan and Lee Molotsky, I'm your host, John DeMasi. As always, a pleasure. Thanks for watching. Good night, Alexa. Good night, Jenna. Talk to you next time right here on Molotsky on Money. Take care.
Do you know what your risk tolerance is when it comes to your investments? Do you know exactly what you have in your portfolio? The SHM Financial Group have developed a very important program called the Financial Stress Test. It's simple, quick, and can help you in your future financial plans. Contact the SHM Financial Group to schedule it. Offices in Collingswood, Voorhees, and Lakehurst, New Jersey. Call 1-800-MONEY-SHM. That's 1-800-666-3974. Call us to discuss the reverse mortgage concept. If you should decide to proceed, you're required to go through a 60-minute phone or office interview. We will provide you with a list of HUD counselors you can call who will provide you with the counseling. Call us at 1-855-HUD-REVERSE. That's 1-855-483-7383.